Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In just 15 minutes we'll keep you abreast of the big commercial legal news stories. So grab a cup of tea, relax and allow us to keep you effortlessly updated with the information that your business can't afford to miss. Data protection warning to the legal professional. Our first item is the first of two stories that we'll cover this month, showing that even legal professionals can sometimes fall foul of the law. The Information Commissioner's Office, the ICO, gave a warning to solicitors and barristers after there had been 15 incidents involving members of the legal profession being reported to the ICO in just a 3-month period. The concern seems to particularly focus on the risks caused by carrying folders of personal information, which is often the case with solicitors when they're travelling to and from court. The ICO has published some top tips for solicitors and barristers that are available on the ICO's website. Naturally, they serve as good guidance for any business that is holding high volumes of personal data. Apps. A study by the Pan-Governmental Global Privacy Enforcement Network shows that most mobile app developers are failing to clearly explain how they are collecting, using and disclosing personal information. The key findings from research were that 85% of apps surveyed failed to clearly explain how they were collecting, using and disclosing personal information. And more than half, that's 59% of the apps, left users struggling to find basic privacy information. And almost 1 in 3 apps appear to request an excessive number of permissions to access additional personal information. Ofcom has now issued a new guide to help people use apps securely and safely. And this new guidance is a helpful read to any business creating or commissioning apps, as it explains what is going to be necessary to ensure that users are given the comfort that their data will be safe. The ICO is publishing its updated CCTV Code of Practice next month. The guidance takes into account developments in the use of CCTV and other forms of video surveillance since the guidance was first published over 10 years ago, including automatic recognition of car number plates through to personal information being collected by flying drones. In addition to the guidance, the ICO will also be producing a webinar to help explain the guidance, and there will be an opportunity to ask questions. Further details are available on the ICO website. We welcome this new guidance, as in our experience CCTV is often overlooked by businesses when reviewing the personal data that they collect. In one recent case we found that a company's CCTV camera was accidentally capturing neighbouring residential houses. An easy mistake to make, but nevertheless it was important that it was corrected to only capture the business premises. The sentencing guideline on fraud, bribery and money laundering offences came into effect on the 1st of October of this year. If found guilty, companies now face fines of up to 400% of their illicit profits. The new guideline also places victim impact at the centre of considerations when determining an appropriate sentence. This may mean higher sentences for some offenders compared with the prior guideline, particularly when the financial loss is relatively small but the impact on the victim is high. The Sentencing Council has also broadened how harm is described, so those passing sentence are not restricted in what they take into account. The QCA Code. The Quoted Companies Alliance has published a revised corporate governance code suitable for small and medium-sized quoted businesses. This best practice document has been developed to take account of the UK Stewardship Code, which aims to enhance quality of engagement between asset managers and companies, and changes to the UK Corporate Governance Code. Copies of the code are available for purchase from the QCA's website. 2 recent cases demonstrate the court's continuing approach to force parties to make reasonable attempts to negotiate a settlement before marching off to court or arbitration. In one case, it was held that a contractual clause to obligate the parties to resolve a dispute by friendly discussions before escalating the matter was enforceable. This is a departure from other cases that have held such clauses to be unenforceable due to uncertainty. In another case involving BAE, where BAE had triumphed at court, there was then an argument over costs. The argument centred on BAE's refusal to mediate. Ultimately, in this case, BAE was not penalised on costs, but only because the other party had also failed to demonstrate a constructive approach to resolving the matter. In particular, he had refused to accept an offer, but it was better that he had ultimately achieved at court. Nevertheless, the court made it clear that even though BAE had been able to demonstrate that he had a strong case, this was not a reasonable excuse for refusing mediation. The lesson is therefore simple. Always take the most constructive route to resolving a dispute. There is a good chance you'll settle and save yourself a significant sum, and even if you're unable to settle, you should be able to avoid being hit with a cost penalty at court. Abandoned calls. ACAS Retail Limited, a specialist insurer to the over 50s, has been fined £10,000 by Ofcom for making abandoned calls. An abandoned phone call occurs when a consumer picks up the receiver but there is no one on the other end of the line. Abandoned calls are usually caused by automated calling systems or dialers which organisations use to maximise the amount of time their calling agents spend speaking to consumers. These systems are mainly used in call centres to dial telephone numbers automatically and connect people to call centre agents as soon as the phone is answered. The Ofcom investigation into ACAS found that the company made 148 abandoned calls to UK consumers over 3 separate days during a 7-week period and was therefore in breach of legislation relating to the persistent misuse of a telephone network or service. Whilst the fine is relatively low, it is noted that the company offered a £10 shopping voucher to affected consumers and has now taken steps to stop this practice. Although this case was dealt with by Ofcom, similar cases will fall within data protection legislation and will be dealt with by the Information Commissioner. We believe that similar actions will swiftly follow against other businesses that operate similar practices. If your business contracts with a call centre, it will make good sense to ensure that they are not operating in this way. As such actions may be prosecuted using data protection legislation, it may be that your business, rather than that of a call centre, is the target. ACAS guidance on bereavement leave. The law gives a right to employees to have reasonable time off work to deal with an emergency such as bereavement involving a dependent. An employer does not have to pay an employee for the time away from work, but there is an obligation to not treat some employees less favourably than others. Employees experiencing mental health issues such as anxiety and depression as a consequence of bereavement may be considered disabled, and the law then requires reasonable adjustments to be made. ACAS has published new guidance which help employers to prepare for managing bereavement in the workplace by having a clear policy. Issues raised include a possible need to offer part-time hours or flexible working if the bereavement means the employee assumes additional duties as a carer. Shutter v Ford Motor Company. This case involved an allegation that Ford's contractual benefits for childcare benefits were more favourable to women than men. The facts of the case were not particularly disputed, and the question therefore turned on whether Ford could justify the discriminatory treatment. Ford put forward evidence that as early as 1999, when policies in relation to maternity pay were being formulated, recruitment and retention of women had been identified by Ford as an objective for its business. The Employment Tribunal was ultimately satisfied that the aim of increasing and retaining women in the workforce is legitimate. In this case, Ford proved that it had got it right. Perhaps more impressively, was also able to show that it had a clear objective to its policies and it had the records to support it. Well done, Ford. Other news in employment. Since the 1st of October, fathers and partners will be entitled to unpaid time off to attend 2 antenatal appointments. And also since the 1st of October, tribunals are given the power to order an employer that has breached equal pay law to carry out an equal pay audit. The Consumer Contract Regulations has now been with us for 3 months, so it's a good opportunity to review. They apply to all contracts between a trader and a consumer, but its contracts are provided off premises or at a distance that have been of particular interest. So now turning to the second case that I promised of examples of solicitors also being able to get the law wrong. We are aware that there have been some instances of solicitors being caught out by not appreciating that this widely drawn legislation can also cover the solicitor-client relationship. Conscious that this has been missed by some solicitors, the Law Society has created a guidance note. A few points in particular to note are: a contract will be off premises even where it has been concluded on business premises immediately after the client was addressed in a place that was not on the business premises. It can be difficult to determine when a contract is made and therefore whether it is an off premises or on premises or distance contract. Failure to provide certain information in an off premises contract may be a criminal offence. The regulations consolidate previous regulations, so are now more onerous. For example, the standard cancellation periods are now 14 days rather than 7, and the information must be provided in the prescribed format. If the requisite notices have not been given, there is a 1-year calling off period. Perhaps more bluntly, that's 1 year's fees that may need to be written off. Of course, it's not just solicitors that can get caught out by these regulations. This is just to demonstrate a common misunderstanding that the regulations only apply to goods contracts. Of course, it's not just solicitors that can be caught out by these regulations. This is just to demonstrate a common misunderstanding that the regulations only apply to goods contracts. There are some exempt categories, but if you do provide goods or services at a distance or off trade premises to a consumer, then reviewing whether your processes and terms are in compliance with the law should be on top of your agenda. Banking reference. In a recent case involving the Playboy Club London, the claimant sought to recover losses it had sustained following a reference being given by the bank for one of its customers. The reference provided that the customer was trustworthy up to the extent of 1.6 million in any 1 week. The customer ran up gambling debts of 1.25 million in a short period of time, and his cheques subsequently bounced. Neither the customer nor his assets could be traced. And it subsequently transpired that when the reference had been written, the customer's account had a nil balance, and therefore the bank was not able to demonstrate that he had exercised a sufficient skill and care in preparing the reference. The bank's arguments that the reference had been given by a junior employee and the reference had been intended for an associated company of the claimant rather than the claimant failed. And the court upheld the claimant's claim with a small reduction because the claimant was contributory negligent to the extent that he should have examined the customer's cheques a little more closely, which would have revealed flaws in the cheques and led to them being refused and the losses avoided. Intellectual property. From the 1st of October, the design provisions in the Intellectual Property Act 2014 have been applicable. The most controversial change is the introduction of criminal sanctions for intentionally copying registered designs. Also, the sanctions are not limited to those doing the copying, but extend to anyone offering, marketing, importing, exporting, using or stocking the design if that person has reason to believe the design has been registered and intentionally copied. If a person, including directors or senior managers of a company, is found guilty of copying a design, despite knowing or having reason to believe it's registered, then a prison sentence of up to 10 years and/or a substantial fine is possible. Another significant shift in the law is that unless it has been agreed otherwise, the ownership of UK unregistered designs will belong to the designer rather than the party that has commissioned the design. To bring the UK into line with EU copyright law, the UK has introduced a new parody exception into competition law. The use of this exception is subject to being able to demonstrate that it constitutes fair dealing, which will severely limit the scope of the exception. Certainly any use for commercial purposes, e.g. advertising, is unlikely to be permitted. The now highly publicised case of Wonga has concluded with Wonga making an agreement to write off loans for 330,000 customers, discard interest and charges for 45,000 customers, and offer them an extended repayment period. And the 6-month transitional period allowed by the Financial Conduct Authority to give firms time to become familiar with the new structure and style of the rules and guidance ended on the 1st of October. Regulated firms must ensure they now comply with the rules, and the FCA has been keen to point out its particular interest in ensuring that such firms are determining the affordability of the agreement for the consumer. Thanks for joining us for this month's Commercial Law Update. The video and podcast are available on the LexisNexis in-house blog page, together with the written report. The website details of LexisNexis and Radius Law will be shown on your screen in a moment. Thank you and goodbye.